In the meantime, the High Court has stopped the enforcement, implementation and operation of some sections of a Computer Misuse and Cybercrimes Amendment Act 2024 signed into law by President William Ruto last Wednesday.
Justice Lawrence Mugambe, sitting in the Constitutional Division of the High Court, urged parties to serve their responses within a fortnight, with the hearing set for Wednesday, November 5th of this year.
In the case, the petitioners state that the laws violate fundamental rights enshrined in the Constitution, claiming it could suppress the freedom of expression and privacy for citizens.
Exactly a week after President William Ruto enacted the Computer Misuse and Cybercrime Amendment Act 2024, the law is being challenged in court. 2 petitions have been filed on the premise the law is vague, goes overboard, and has weakened Kenya's Data Protection Act of 2019. All filed under certificate of urgency. The petitioners, former presidential aspirant Reuben Kigame and Kenya Human Rights Commission and activist Francis Owino, want implementation of the contested provisions in the law grant law enforcement agencies, if left unchecked, powers that could be used to silence journalists and critics of government policies, leading to arrest and prosecution.
We're going to use all the conventional and constitutional means possible to make sure that we fight for the justice and to make sure that the rights of Kenyans will not be sabotaged by individuals in power.
They further argue that Section 27 of the amended law gravely violates the Constitution by criminalizing online speech and granting the National Computer and Cybercrime Coordination Committee powers to block websites and social media platforms without judicial oversight.
Tukasema badala ya twende kwa barabara, acha kwanza tutumie diplomacy ndio aone sisi kama vijana tunamheshimu. Tumeamua tutumie diplomacy. Tukuje kotini na tukafile petition.
They further argue that Section 27 of the amended law gravely violates the Constitution by criminalizing online speech and granting the National Computer and Cybercrimes Coordination Committee powers to block websites and social media platforms without judicial oversight. The petitioners seek multiple declarations that the new law is unconstitutional, null and void, arguing that it infringes on the rights to privacy, freedom of expression, access to information, and fair administrative action. And in a swift move, Justice Lawrence Mugambe has suspended the implementation of some sections of the Computer Misuse and Cybercrime Amendment Act 2024 that was signed into law. The judge has directed parties to file their responses and rejoined us within 13 days, with further direction set for early next month. Ruth Wamboi for Prime Edition.